All right, today we're going to tackle something called tort law. Now, I know it sounds kind of intimidating, right? But at its heart, it's really all about the unspoken rules of daily life. It's the legal framework that sketches out our basic responsibilities to each other, just to make sure we can all get through the day safely. I mean, think about it for a second. You slip on a wet floor in a supermarket, a new gadget you bought turns out to be faulty, or maybe there's a car accident because someone was distracted for just a moment. Who's on the hook when carelessness leads to that kind of harm? Well, these are the exact kinds of questions that tort law was designed to answer. Okay, so before we can even start to figure out who's responsible, we need to get back to basics and ask the most fundamental question of all. What in the world is a tort? To put it simply, a tort is just a wrongful act that causes someone else to suffer some kind of loss or harm. Now, notice the term civil wrong. That's key. It means this is an issue between people, not a crime against the government. So if a tort is proven, the court's goal isn't to punish anyone with jail time. Instead, it's all about compensating the person who is injured, usually with money. Now, you might be thinking, hold on, isn't that what contracts are for? And that's a great question, but they're actually quite different. See, contract law is all about duties we voluntarily agree to, like when you sign a deal. Tort law, on the other hand, deals with duties we owe to pretty much everyone in society, whether we've made an agreement with them or not. It's the baseline of care we all have to show each other. Now, sure, there are torts where people do things on purpose, things like defamation or fraud, but the one that pops up the most in our everyday lives is the unintentional tort of negligence. And this is all about harm that's caused not by someone trying to be malicious, but simply by their carelessness. So how do you actually prove someone was negligent? It's not just a gut feeling. The law has developed this really clear three-part test that a person has to satisfy to have a successful claim. Let's break that down. This three-step framework is the absolute blueprint for any negligence claim. To win, a claimant has to prove all three of these things. Not one, not two, all three. First, that a duty of care was owed to them. Second, that this duty was broken or breached. And finally, that the breach is what directly caused their loss or injury. So let's dig into that first crucial element, the duty of care. To really get where this idea even comes from, we actually need to travel back in time to a famous case from 1932. It's a wild story that involves a cafe, a bottle of ginger beer, and a very unfortunate snail. So picture this. A woman named May Donahue is in a cafe in Scotland. Her friend buys her a bottle of ginger beer. She drinks some of it, but when her friend pours the rest into her glass, out comes the decomposed remains of a snail. Yikes. Mrs. Donahue got sick, but here's the twist. She couldn't sue the cafe owner because her friend was the one who actually bought the drink. So she took a huge leap and sued the manufacturer, a Mr. Stevenson. This created a massive legal puzzle. Back then, you generally needed a contract with someone to sue them. But Mrs. Donahue had no contract with the manufacturer. So the big question for the court was this: did Mr. Stevenson owe any kind of responsibility, any duty of care, to the random person who would eventually drink his product? And the court's answer, laid out brilliantly by a judge named Lord Atkin, literally changed everything. He said this: "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor." This one sentence gave birth to what we now call the neighbor principle. It created this broad, general duty to be careful and not harm people who we can reasonably predict our actions might affect. So, who is your legal neighbor? Well, it's not just the person living next door. According to this principle, it's anyone who is so closely and directly affected by what you do that you should really be thinking about them. It could be the driver in the car next to you, a patient being treated by a doctor, or, the person who eventually ends up drinking your ginger beer. And over the years, Lord Atkin's neighbor principle has been applied so many times that it's created what we call established duties of care. Basically, in certain relationships, the law just automatically says, yep, a duty exists here. And here are just a few of the most common examples. Okay, so establishing a duty of care is only step one. We've still got to complete the test. So now we need to look at the other two parts, breach and causation. So a breach happens when someone's behavior falls below the standard of care that's required. And what's that standard? Well, it's measured against this idea of the reasonable person. And this is totally objective. It doesn't matter if the person thought they were being careful. The real question is, what would a hypothetical, sensible, prudent person have done in that exact same situation? To figure out if a breach happened, courts do this kind of balancing act where they weigh these four factors. First, how probable was it that harm would happen? Was it a freak accident or almost guaranteed? Second, how serious was the potential harm? Are we talking a scraped knee or a life-changing injury? Third, how hard would it have been to take precautions? Was there a simple, cheap fix? And finally, they look at the social utility, the social value of what was going on. For example, we view the risks an ambulance driver takes very differently than the risks a reckless joyrider takes. And now we've reached the final hurdle, causation. See, it's not enough to just show there was a duty of care and that it was breached. The claimant has to prove that the defendant's specific screw-up is what actually caused their injury or loss. You have to connect the dots. The main tool for this is the but-for test. You just ask the question, but for the defendant's action, would the harm have occurred anyway? Now, sometimes things are more complicated. Maybe there are multiple possible causes. In those cases, courts might use a broader test and ask, did the defendant's carelessness materially contribute to the harm? Phew, okay, we've covered duty, breach, and causation. So let's pull all of this together and really get to the bottom line. Why does any of this legal stuff matter in our day-to-day lives? You can really think of this whole thing as a simple three-part checklist. This is the core logic that courts and lawyers use every single day to make huge decisions about responsibility, affecting everything from the factory floor to the hospital operating room. Because at the end of the day, tort law, and especially negligence, isn't just some dusty old topic for law books. It sets the standard for how we should treat each other. It's a powerful legal reminder that our actions have consequences and that we have a basic obligation to think about the safety and well-being of the people around us. And that leaves us with one final thought. The next time you get in your car, or send an email at work, or even just walk down a busy street, take a second and apply that principle from 1932. Who is so closely and directly affected by what you're doing that you should have them in your mind? Who is your neighbor?